that demonstrates an absence of willfulness for the purposes of the so-called non-compliance, because there's a legal issue that is sought to be determined before that compliance and or non-compliance can arise. But I've heard what Commissioner Baloy has said, and Commissioner Baloy's view is that that is not correct, and that notwithstanding your application and please correct me if I'm wrong, you actually should have complied, and that your failure to comply is what has caused the concern for the Commission. I hear that, and I accept the remarks made by Commissioner Baloy. Obviously I do, but I would say that the fullness of the answer that I can give is that he didn't sit back and simply not comply. He came to the very body that will determine the consequences of his compliance or non-compliance on the 27th, and said, please give me a directive on this particular issue that is materially connected to that compliance which I know I have to comply with. If that was the wrong approach, that is the wrong approach, and we have to take the proverbial beating that we receive for that. But as long as it is on record that my client didn't just simply write a letter or sit back or sat on his hands, but that he engaged a formal procedural process to help him clarify the terms of his compliance in respect of that particular date, then that's as far as I can take it. But I take that, Commissioner Baloy, and may I also say on the record that this is now the third instance that the Commission has raised languaging and stridency in the conduct of the legal team, in the conduct of Mr. Carrim's legal team. As Mr. Carrim's leading counsel, I will take responsibility for that, and I again apologize to the Commission for those terms, but I hope the Commission will understand that the obligation on us, as Mr. Carrim's legal representatives, in circumstances where he could be the subject of coercive force, is to represent him to the best of our ability with no regard to personal consequence, fear, or favor. And so I take the admonition in the way that it is delivered, and just to assure the Commission that that was never meant as a sign of disrespect or willful non-compliance, but it was in what we see as the legitimate pursuit of our responsibilities to our client as his legal representatives. Thank you, Chair. Thank you, Commissioner Baloy.
Accept that, Mr. Premhid.
To speak for themselves, and allegations are made in the papers that affect the officers of this commission. I just want to place it on record that the rules of this commission require that they take the oath of secrecy to preserve confidentiality of any document that comes to this commission. And Regulation 12 says if they breach some of those regulations, it is an offense. So all of them take that obligation very seriously. And we as commissioners, we administer that oath. And we make it clear to them that, these are your obligations. Everything that comes here is to be treated as confidential. I just needed you to know that, and any other witness that comes after your client, they know that. So that allegations should not be made that if officers of this commission come across statements or documents, they won't treat them with confidentiality. I think it's very important that that is made clear, because that was the fear, as I understood it, and it is put on affidavit. They don't get to speak for themselves, but we know the regulations. As I said, some of these documents are on the website. So can we just understand that, so that going forward, that that is the position? It is not directed just to your client, but anybody that comes after your client.
Of which I assume there's going to be many. But
I hope they don't repeat what was said this morning.
Commissioner Khumalo, may I say I accept that. And indeed, had the confirmatory statement of what you just put to me, which we received in the directive on the 3rd of March, in paragraph 7, be said on the 18th of February, then that might have changed our position being in front of you. But I've heard what you've said, and I'm sure all the television cameras have flighted that as well. Thank you, Commissioner.
If they repeat it, I'm going to blame you.
Wouldn't be the first time, Commissioner Khumalo.
You wanted to say, or should I quickly raise my issues and then you come thereafter? You want to come in now? Chair, it is related to the issue of.
I just hope it won't result in an unending ping pong.
No, Chair, I'm sure you will ensure that it doesn't.
Yes.
It really is to say two things. The first is that the effect of bringing the application on the 18th of February was not to suspend the ruling of the 27th of Feb. And so I hear my learned friend saying,
I think that was the first, or after my preliminary point, I think that was one of the very first issues I raised. I think Commissioner Baloyi as well has touched on it. I think the point has been made in that regard.
I won't say anything further on
Yes,
it, except
yes.
it was important from our perspective,
Yes,
as
yes.
the evidence leaders, because
Yes,
there are allegations that are being made about the evidence leaders
Yes, okay.
in this. And so it doesn't suspend the ruling. It was
Yes,
important from the point of view of the evidence leaders and the way in which they handled
Yes.
that application going forward. But the second thing was that my learned friend said that the statement was materially connected to the application. And that was not at all apparent, and until this moment, it's still not apparent to me how it is materially connected to the application. If Mr. Carrim had said, my statement will contain information that cannot be disclosed, and that it's part of my application for the in-camera hearing. Part of why I need this is because I'm going to say something that has to be kept confidential. That I understand, but that's not the ground that was advanced in the application. And what is in the statement is not anything that has not already been said in public in the High Court by the witness.
Thank you, Ms. Hassim. A quick response to the second point only, please, Mr. Premhid, if you have it.
All I'll say is that I don't know what more my client can be expected to do in the circumstances where he comes to the commission, places the application and the correspondence where the exact justification sought by my learned friend is placed. And that's not to do what my learned friend has, I think, suggested, which is that it's about the content of the statement. It's about the status of disclosure it's the status of the hearing prior to the disclosure of the statement, not the content of the statement itself. So that's consistent, the consistent line we've taken in these proceedings.
Thank you, Mr. Premhid. I have two very brief points to raise. There's the issue of the offer of protection. There's a dispute as to whether the offer was made previously. I will leave that and proceed to what the attitude is now, because Ms. Hassim has said the offer is being extended even as we speak. Is there a response? If not, will a response be given to the evidence leaders as soon as possible in this regard?
Chair, may I say that we have to take an instruction and we'll
All right.
give a response, but I must just
All right.
say this.
Yes.
My client is scheduled to come before this commission within 48 hours. My
Yes,
learned friend
yes.
was talking about things like threats assessments and all these other kinds of investigations that need to happen. So I mean, practically speaking, even if he wants to accept that, I don't know to what extent all of the necessary processes are completed within the 48 hours that he has available. But we'll take an instruction and we'll come back to you on that. Thank you, Chair.
Thank you. Then there's also the issue of the supplementary bundle. This morning I understood you to accept that that's due today and that you will accept it when it's furnished today. But when you were arguing this afternoon, I understood you to be saying it was due at a specific time this morning and that by now it's late already. I just want to understand what exactly you are saying in this regard. What's the point of substance being made in this regard? Are you saying it's late and therefore your client will be prejudiced if your client gets it later than whatever the morning time was?
Yes. And the reason for that is that we were under a time pressure to file by a particular time. That was specified in the directive handed down as 9 o'clock. 2 days later, business days later, 9 o'clock, The statement, the supplementary bundle has not been given. We are now here on the Friday afternoon at 3:15. I'm instructed it's still not been given.
What were the exact terms of, for the filing of that?
You'll remember that comes from the original order you
Yes,
gave in the
but
context of
what were the exact terms?
within 48 hours of the receipt of the statement. And so now I'm saying 48 hours has actually lapsed. And I'm not just complaining that 48 hours has lapsed. What that has an impact on is from Friday 9 o'clock until my client has to appear in front of you on Monday at 9 o'clock or whatever the actual time is, the absence of the bundle since this morning is now eating into our
What time was it this morning?
9
9.
that we had to deliver the statement yet. We had
No,
to,
no, the bundle, the supplementary
we would
bundle.
have anticipated it 2 days later, meaning 9 o'clock today in the
Today,
morning.
9 today.
Yeah.
And at 9:30 you were here.
And it hasn't come.
And would you have used it meaningfully, or is this a technical point?
No, we
Mr.
would have.
Mr.
As you might notice, one of my team is not here today because he's off sick. But he would have been the one to take up, he was off sick and not present because he has a contagious illness, which means he should be isolated. But he would have been in the position to already start looking at that bundle, engaging our client, and so on. And so that's just the reality of where we are placed.
But Mr. Premhid, this point about the exact hour was not made this morning. This morning you seem to accept that this bundle is to be given to us today. And it was already past 9 o'clock, and you did not suggest that you are late because you did not give this to me at 9 o'clock. It seems to me that this is an about 10, and I'm not taking kindly to that at all.
No, I accept what you say to me, Chair, and I'll say that it's not an about turn because when we were given the short...
It is. If after 9:30, when argument commenced, if after 9:30 you said the supplementary bundle is due today, and you said it in a context that was receptive to the idea of that being given to you later than the start time of the argument, all of a sudden now you are insisting on 9, and you are already past 9 when you made this point. That is why I'm saying this is an about 10. If you want to, we can actually listen exactly to what you said. And I think I'm correct on this.
No, I don't think that's necessary. And I hear what you say to me, Chair, but all I'll say is that even if 9 o'clock wasn't the fixed time, or alternatively, my failure to mention the 9 o'clock issue when I addressed you earlier now causes the effect that it didn't have to be given at 9 o'clock. The point that I would make simply is that it's now Friday afternoon, or almost 4 o'clock.
Do you remember as you were arguing, I think I even asked Ms. Hassim, will this supplementary bundle be served today? And you said yes. And Mr. Premhid, you never said, but that will be late already. You never said so.
Chair, may I?
Yes.
I?
Yes.
Because what is happening here is important. It's again the applicant creating rules and demands.
No, please respond when Mr. Premhid is done. Let's just continue with the debate with Mr. Premhid.
It's on the same point, Chair, but okay.
No, so that you don't, it doesn't become a dialogue between you.
I never know when Mr. Premhid's done or not.
Yeah, no, you're still arguing. I hope you follow what I'm saying, Mr. Premhid. After 9:30, during your argument, you, in a manner that is receptive to the idea, accept that the bundle is going to be served. You do not appear to be opposing that on the basis that it was supposed to have been served at 9 o'clock, and therefore it's late already. You did none of that. If anything, as I've said, I think 2 times already, you were receptive to the idea that the supplementary bundle was going to be served after 9 a.m. in the morning. it's on that basis that I say I see this as nothing but an about turn. It's on that basis that I say so. And I added that I do not take kindly to it.
Chairperson, I'm instructed that the bundle has now been emailed to us whilst we've been having this engagement. So my prejudice is cured.
Thank you very much. Thank you very much. Those are the only two issues I wish to raise. I wished to raise with you, Mr. Premhid. Oh, I don't want it to get to the ping pong that I said I do not want
No.
it to become.
No.
This issue has been resolved now, Ms. Hassim.
Chair, can I just put one point of clarity? There was never any agreement that would be filed by 9 o'clock this morning.
No. I understand that perfectly, but I understand the point to arise from a mathematical calculation of 48 hours, not that there was any agreement. But I'm saying what I said despite the mathematical calculation because I just find it very strange. Yeah.
I appreciate that, Chair. My point is not about yours, it was about...
No.
Even the 48 hours was never...
I guess I'm addressing
Yes.
Mr. Carrim through you. Yes.
It's merely to say that the 48 hours was never an agreement.
No.
The 48 hours comes from your ruling on the 6th of February
Yes,
relating to a different
Yes.
set of documents.
All right. No, thank you.
Thank you, Chair.
Thank you, Council. Thank you all, to all of you. I will make my ruling on this at 9:30 on Monday, and I hope that it will be a written ruling which will cover both the reasons for this morning's ruling and also then the ruling on the aspect that's been argued now, plus the reasons for it. We earlier touched on the possibility of the filing of a supplementary affidavit on the issues that I engaged Mr. Premhid on. I do not even trust my memory to be able to articulate those. I trust your memory more than mine, Mr. Premhid, on that.
To interrupt you whilst you are talking, but my learned friend indicated she also doesn't remember. I remember that this possible supplementary statement is to deal with issues such as who could potentially be the source
Yes,
of those
that
threats.
was the thrust of it.
Yes,
That was the main.
the circumstances
Yes,
and
yes.
the reasonable
Yes.
version of the
That
crime.
was the
Yes.
thrust of it.
Yes.
Thank you. I direct that a supplementary affidavit, if any, underline if any, must be filed by midday tomorrow, and a response to it, if any, by 7 p.m. tomorrow. That's the direction, but I may just add that by making the direction, we're not necessarily saying that